Losing a loved one is undeniably one of life's most difficult moments. While families gather to comfort one another, they often face a daunting and unexpected hurdle. The emotional toll is quickly compounded by the heavy burden of navigating complex legal paperwork and searching for the deceased's final wishes. Sometimes, amidst those stacks of formal documents, a family might discover something much simpler: a last will and testament written entirely by hand. In the legal world, this is known as a holographic will. But are these handwritten notes legally binding? The answer is complex and depends entirely on where you live. In this video, we'll guide you through the rules and state laws surrounding holographic wills, helping you understand what makes them valid. Please keep in mind that this content is for informational purposes only and does not constitute formal legal advice. What exactly is a holographic will? In legal terms, a holographic will is simply a last will and testament that is entirely handwritten and signed by the person making it, known as the testator. Unlike a formal typed will drafted by a lawyer, this document is created entirely by your own hand. To be considered legally valid, a holographic will must generally meet 4 key characteristics. First, it must be completely handwritten. Even a single typed paragraph or using a fill-in-the-blank form can invalidate it. Second, it must be clearly signed by you. The third characteristic is what makes them so unique. In most states that allow them, holographic wills do not require the signatures of any witnesses. While standard wills require at least 2 people to watch you sign, a holographic will relies entirely on your handwriting. Finally, the document must show clear testamentary intent. The writing must explicitly state how you want your property distributed after your passing. A simple note isn't enough. It must give clear instructions, like explicitly leaving your house to your daughter. Not all states treat handwritten wills the same. In fact, whether your holographic will is valid depends entirely on where you live. Let's look at the map. Currently, about half of the U.S. states recognize handwritten, unwitnessed wills to some degree, but the rules can vary wildly from one state border to the next. Let's look at California. Here, a holographic will is valid as long as the signature and material provisions are in your handwriting. But there is a crucial catch. It should be clearly dated. While an undated handwritten will isn't automatically void, omitting the date can cause major legal headaches if there's confusion about which will is your most recent. Down south in Louisiana, things are a bit different. Based on French civil code, they call it an holographic testament, spelled without an H. To be valid, it must be entirely written, dated, and signed in the testator's handwriting. You don't need witnesses present when writing it. However, during probate, the court will require 2 witnesses to verify that the handwriting is actually yours. Over in Texas, the rules are famously straightforward. A holographic will is valid as long as it is wholly written in your handwriting and signed. You don't need witnesses to watch you sign it, and you don't need a notary. As long as it is 100% handwritten, Texas courts will generally respect your wishes. Remember, always check local laws, as requirements can change. While many states accept holographic wills, a significant portion of the country flatly rejects them. States like Florida, Ohio, and Illinois require formal witness documents, meaning a handwritten will there is legally void. So why would anyone rely on one? Often it comes down to emergencies. In a sudden medical crisis or a life-threatening situation, quickly writing down your final wishes on a notepad might be the only available option. Others choose them to avoid dense legal jargon or to leave a deeply personal handwritten legacy. However, without professional guidance, these wills have very limited legal utility and are frequently challenged in probate court. Once the creator of a holographic will passes away, the legal journey begins in probate court. Unlike standard wills drafted by attorneys, the probate process for a handwritten will is notoriously complex and heavily scrutinized. It starts with filing the document with the court clerk and officially notifying all potential heirs and beneficiaries. When beneficiaries receive these legal notices, it often triggers anxiety. Because holographic wills are usually drafted in private without any legal guidance, their sudden appearance can catch family members entirely by surprise, setting the stage for confusion and bitter legal battles. The most critical hurdle in this process is proving the document's absolute authenticity. The court must be certain the handwriting matches the deceased. This requires sworn testimony from reliable witnesses intimately familiar with the testator's handwriting. In disputed cases, courts bring in forensic document examiners to analyze pen pressure, stroke patterns, and ink composition. Even if the handwriting is verified, holographic wills frequently face intense legal challenges. Unhappy relatives might argue a lack of testamentary capacity, claiming the deceased was not of sound mind when writing the document. Others might allege undue influence, suggesting a third party pressured them into it, or they might claim outright forgery. Sometimes, a holographic will includes a self-proving affidavit, a notarized statement that can speed up the authenticity checks, though this is extremely rare. Ultimately, navigating these objections involves multiple court hearings, concluding only when a judge makes a final ruling on whether those handwritten wishes will be honored. While a holographic will might seem convenient, it comes with significant risks. Handwritten documents are notoriously difficult to validate in probate court. They often contain ambiguous language and frequently omit crucial details, such as naming guardians for minor children. Because they lack formal witness signatures, they are far more susceptible to claims of forgery, errors, and lengthy family disputes that can drain the resources of the estate. To protect your loved ones and ensure your wishes are honored, consider safer alternatives. A formal, typed will, drafted and signed in the presence of a legal professional and witnesses, is the gold standard. If cost is a concern, reputable online will-making services offer legally sound, state-specific templates. Alternatively, establishing a living trust can provide comprehensive control over your assets and allow your estate to bypass the costly probate process entirely. While creating a holographic will might seem straightforward, consulting with an experienced estate planning attorney is the best way to ensure your final wishes are properly executed and legally binding. Please remember that the information provided in this video is for educational purposes only and does not constitute legal advice. Every state has unique laws, and your specific situation requires personalized professional guidance. To learn more about estate planning and find helpful tools for your journey, visit funeralus.com today. Thank you so much for watching and learning about holographic wills with us today. Remember, state laws can be tricky, and handwritten wills often face strict scrutiny in probate court. We highly recommend seeking professional legal advice to ensure your final wishes are protected. If you found this helpful, please like this video, subscribe to our channel, and leave a comment below with your thoughts or questions. We will see you in the next one.